Hello, everyone, and welcome back to English Mini Classroom. This session is designed for C1 level English learners. Today, we will analyze a reading comprehension passage from the 2021 postgraduate entrance exam, which explores the ongoing debates and legal battles surrounding net neutrality and broadband providers. This article is an excellent material for improving our English comprehension and discussion skills. From the early days of broadband, advocates for consumers and web-based companies worried that the cable and phone companies selling broadband connections had the power and incentive to favor affiliated websites over their rivals. That's why there has been such a strong demand for rules that would prevent broadband providers, from picking winners and losers online, preserving the freedom and innovation that have been the lifeblood of the internet. Yet that demand has been almost impossible to fill, in part because of pushback from broadband providers, anti-regulatory conservatives, and the courts. A federal appeals court weighed in again Tuesday, but instead of providing a badly needed resolution, it only prolonged the fight. At issue before the U.S. Court of Appeals for the District of Columbia Circuit was the latest take of the Federal Communications Commission on net neutrality, adopted on a party-line vote in 2017. The Republican-penned order not only eliminated the strict net neutrality rules the FCC had adopted when it had a Democratic majority in 2015, but rejected the Commission's authority to require broadband providers to do much of anything. The order also declared that state and local governments couldn't regulate broadband providers either. The Commission argued that other agencies would protect against anti-competitive behavior, such as a broadband providing conglomerate like American Telephone and Telegraph Company favoring its own video streaming service at the expense of Netflix and Apple TV. Yet the FCC also ended the investigations of broadband providers that impose data caps on their rivals' streaming services, but not their own. On Tuesday, the appeals court unanimously upheld the 2017 order deregulating broadband providers, citing a Supreme Court ruling from 2005 that upheld a similarly deregulatory move. But Judge Patricia Millett rightly argued in a concurring opinion that the result is unhinged from the realities of modern broadband service, and said Congress or the Supreme Court could intervene to avoid trapping internet regulation in technological anachronism. In the meantime, the court threw out the VFCC's attempt to block all state rules on net neutrality, while preserving the Commission's power to preempt individual state laws that undermine its order. That means more battles like the one now going on between the Justice Department and California, which enacted a tough net neutrality law in the wake of the FCC's application. The endless legal battles and back and forth at the FCC cry out for Congress to act. It needs to give the Commission explicit authority once and for all to bar broadband providers from meddling in the traffic on their network and to create clear rules protecting openness and innovation online. Now that we have read the article, I would like you to reflect on the following questions and share your thoughts. 1. What has long been a concern about broadband providers? 2. How has the FCC responded to the demand for net neutrality rules? 3. What can be inferred about AT&T from the text? 4. What is Judge Patricia Millett's opinion on the appeals court's decision? 5. What does the author argue Congress needs to do to ensure net neutrality? Please leave your answers in the comments below, and let's see how well you understand the complexities of this exam section. Remember, engaging in discussions about real exam questions is a great way to improve your language skills. Thank you for watching English Mini Classroom. See you next time.